There was a hearing just last week in front of Judge Royce Lamberth here in the U.S. District Court for the District of Columbia, and the hearing had to do with something called discovery.
Yes.
Our viewers may not know what discovery is necessarily, but it's a legal means by which we gather evidence and information.
Yes.
Tell us a little bit about the hearing and what Judge Lamberth ruled on.
Sure. So discovery is a fact-finding process that attorneys use. And in the case that we have against the State Department, it's actually a FOIA case. It's a Freedom of Information Act case for records relating to Benghazi talking points. We asked for these records back in 2014 from the Secretary's office.
So this is a 5-year case,
Yes.
so 5 years of litigation to find out about this case.
Yes. And we, throughout the process, obviously, we had previously requested that the judge or that the court grant us discovery because there was evidence of bad faith by the State Department with respect to this case and not telling us that they were missing Secretary Clinton's emails at the same time they were trying to settle the case with Judicial Watch.
Okay, this is an important point, so I want to pause for a second and focus on the idea of bad faith on the part of the government with respect to producing these emails to us. I think for context, it's important to remember that this is actually our second case concerning Hillary Clinton's emails at the State Department and actually her outlaw server where she ran all these emails. Another judge, Judge Emmett Sullivan, in a separate piece of litigation, also granted us discovery.
Correct.
How unusual is it for a judge to grant discovery in a Freedom of Information Act lawsuit?
It's very unusual. Discovery is rare in FOIA. Typically, the courts and the judges will give deference to the agency's declarations, which just means submissions under oath in writing to the court, where they searched and that they did everything they're supposed to do.
So when you mention bad faith with respect to that, in regular, normal English terms, what is the judge getting at when he talks about a question of bad faith?
Well, the question of bad faith is honesty to the court and to Judicial Watch, the plaintiff. If you're trying, I mean, the State Department in this case came and told Judicial Watch in November of 2014, we've searched for all the records. Here are 4 documents, which we've actually received in a previous FOIA case. And we've done everything we can. Would you like to settle the case? All the while knowing at that point the State Department had already asked for Secretary Clinton's emails, and several weeks later they received 12 banker boxes of her emails, and they were trying to settle. So it's dishonesty. That's pretty much, if I were to use one word.
Bob, you've been an attorney at the Justice Department in your past life before
Yes.
joining Judicial Watch.
Yes.
What sort of emotion does it elicit within the Justice Department when a judge raises a question of bad faith?
People remember it for decades. It's extremely rare.
Right.
It's a career ender a lot of times. I don't know what the ramifications have been here, but you also got, Ramona, you got sworn testimony discovery. I mean, we say discovery. They had to produce people, right, who you got to depose under oath. I mean, that's remarkable.
It's an
right?
extraordinary lineup of folks also. People within Mrs. Clinton's circle, folks like Cheryl Mills, Huma Abedin. I don't know that our viewers appreciate that not only is it extraordinary to get discovery in these matters, but the fact of taking live depositions or testimony from these folks under oath, it's remarkable. So back to our hearing, we asked for some folks to be deposed, and tell us a little bit about that.
Right. So I'm sorry, I gave you a little bit of background because at the hearing, we had already concluded, Judge Lamberth had granted us in the winter, in December and January, permission to depose about 10 or 11 witnesses in this case. And then he said at the end of that, come back and we'll see if there's additional discovery that Judicial Watch needs. And so that's where we were last week. We presented the court, to the court a list of witnesses, additional witnesses that we need to depose because of additional new information that we found in the discovery that had taken place in the last 6 months.
So this first set of depositions, these questions under oath, actually unearth new information, new facts.
Yes.
And that actually drives the second request where we say, look, we need to talk to more people because as we dig at this, new facts are popping up that we need to...
Right. And as Judge Lamberth said at the hearing, actually, the new information really raises a lot more questions than it did answers. And so Judge Lamberth granted us just about all of the discovery we requested, except for 2 depositions.
And those 2
we'll get to
depositions
those.
are, who are they?
Secretary Clinton and her former Chief of Staff, Cheryl Mills. The judge, their attorneys were present at the hearing, and they requested that they have 30 days to respond to Judicial Watch's request, and Judge Lamberth granted that, and their responses will be due, I believe, September 23rd, and then we'll have 10 days to submit a reply as to why we need their depositions, and then Judge Lamberth, I suspect, will rule on that in fairly short order.
So as a non-attorney, I can tell you, sitting in the courtroom, it was my impression at least, that this is pretty astounding stuff, that this is really a remarkable advance in clearing up. I mean, like my impression, in my past life, I was a counterintelligence officer, and I've done national security crime investigations. I'm not guessing at this. I know firsthand how it's done. And I know how the Clinton email investigation was conducted. Mm-hmm. And I know that Mr. Comey, when he gave his briefing on the 5th of July, 2016, invented something entirely new with respect to the criminal code concerning mishandling of national defense information. And that is he injected into the formula, which does not exist in the law, this idea of intent. And so I think part of what our efforts to get these records really go to is intent. And that's sort of this fabrication that Mr. Comey, I mean, he fabricated it and then he lied about it. The efforts of our litigation to get these records, I think, again, outside looking in, not an attorney, but I noticed sort of the tone and tenor of the attorneys representing the Justice Department and the State Department, the government attorneys. I think that they are not simply discussing the production of records. To me, it's a very sort of emotional, agenda-filled defense where they are, it's not a dispassionate argument over records and what the law requires or doesn't require. I get the impression that they're trying to win, not produce records, not necessarily be forthcoming about what they have or what they don't have when they learn they had it, but they're fighting, and not in the, again, my impression, not in the sense of just making a good legal argument, but this is the Justice Department and the State Department, in my opinion, really doing all they can to cover up for Mrs. Clinton. And when I watch that and see that, it's a head scratcher for me, because I don't know if Attorney General Barr knows that. I certainly don't know if the President knows that or not. But this is a really pretty fundamental issue with respect to a person setting up a email server outside the government channels, sending lots of classified information across it. And it's just sort of a yes or no, do you have the records or not? And it's gotten very muddled since then.
Yeah.
Yeah, it's, Bob, you know, in the course of your experience as a Justice Department attorney, I know that sometimes people get invested in cases. You know, they get very emotional and very personally dedicated into a particular case. But you have, again, you're not an attorney on this case, but you have an informed opinion on these things.
Yeah.
I
think I may drop Justice Department from my resume.
Have you seen this level of sort of?
Of course, and it can get very strange. I mean, people view the Justice Department and their residence in the government as some sort of personal, their bailiwick or where they're supposed to be.
Right.
And decisions are made based on what your friends want and what your enemies don't want. And
right.
It can get crazy. And I mean, I don't know, but it sounds like something a little crazy is going on.
A little, I mean, I would say, so Judge Lamberth asked for the parties to submit in writing the day before as to what the positions are.
Right.
And to be honest with you, it really did surprise me that the State Department's position was absolutely no discovery, because there was some very important information that we found in the previous discovery that goes to an inquiry in 2013 that the State Department had made with respect to Secretary Clinton's emails, a directive that was issued in August of 2013, and this is all from the deposition of former State Department official John Hackett,
right.
Where he said, we need to find out what Secretary Clinton's email practices were before we send any more responses to any FOIA requesters and say that relate to her emails and say we don't have any records. So that's part of, I mean, those facts are highly relevant. This is a year before, well before our FOIA request.
Right.
So that's very relevant to the claims that Judicial Watch has in this case. And we are asking even for the records that pertain to that directive, for example.
So
and
I think the idea is here that State Department officials had guilty knowledge, my term, my language, had sort of guilty knowledge of what was really going on. We're sort of scrambling to deal with it, and then when caught, in my view, covered up on this. And that's what's really sort of behind all this, is that there's a lot of baggage that gets dragged out because of the questions that we've asked.
Well, it is, but their position is pretty much, what difference does it make? You know,
We've heard that expression before.
Right.
We've heard that expression before.